I want to welcome everyone to the presentation by the real estate section of the Beverly Hills Bar Association today. My name is Howard Gould. I'm a co-chair of the real estate section. I want to remind everybody that you'll receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, our members only community. So please take a moment to complete also the survey that's included when you get your certificate. I also want to let everyone know about our upcoming programs. March 17th, we have Chris O'Neill, who's spoken for us before, who's a real property tax expert. And he's going to talk about the Prop 13 initiatives that he sees are going to be on the ballot in the fall in further attempts to roll back Proposition 13. We anticipate doing something we don't normally do, but we're probably going to do back-to-back real property tax programs. April 21, we anticipate having Brad Marsh from Greenberg Traurig talking about Prop 19, which you may remember was the proposition the California Association of Realtors pushed that diminished the real property tax benefits that families got when someone died and there was a succession in ownership. And Brad is going to talk about the consequences they're seeing from Prop 19, updates on Prop 19, and workarounds, which of course will be the interesting part most people will want to hear about, is what workarounds have lawyers found to help people who are finding their burdens of property taxes have increased a lot after Prop 19. May 17th, we're going to have an unusual program. We're anticipating a speaker, Thomas Gaffney, talking about blockchain in real estate transactions. Also would like to encourage anyone interested in working with us and putting on programs to join the executive committee of the real estate section. We're meeting virtually these days, and we're always happy to have more people participating. We're very, very happy to again have Larry Jacobson back for today's program. You may know that Larry does the CEB program on updates on the cases from the prior year that affect real estate, and then he graciously does our program as well. Larry's a double graduate of UCLA, undergrad and law school, was a senior editor of the UCLA Law Review, graduated as a member of Order of the Coif. In his over 5 decades of practice, he has extensive experience in real estate and business matters, including business entity formation and restructure, purchase and sale of businesses, succession planning, purchase, sale, management, and refinance of commercial and residential real estate, and tax-free exchanges. Larry has written and lectured extensively on business, real estate, and ethics-related matters, having taught for the USC Broker Development Program and Graduate Realtors Institute of the California Association of Realtors, where Larry is the former vice president of legal affairs. Larry's also been legal counsel to the Beverly Hills Board of Realtors, San Fernando Valley Board of Realtors, California, and California counsel to an international real estate brokerage firm, as well as working with the Newport Beach Association of Realtors. He's also been a member of the California State Bar Real Estate Sales and Brokerage Steering Committee. Larry served as a judge pro tem, both in LA and Beverly Hills, as an adjunct professor of law in the area of real estate secured transactions and administrative law. And Larry these days spends a great deal of his time testifying as an expert witness in cases involving the interpretation of real estate documents, real estate and mortgage brokers' standard of care, and legal malpractice involving real estate, corporate finance, merger and acquisition, legal ethics, and fee disputes. So, Larry, great to see you back, and we can't wait to hear about the most important real estate cases from 2021. Thank you.
Thank you, Howard. After that introduction, I guess all we have to do is wrap up and close. When I laid out the cases for the discussion, I think I probably bit off a little more than I could chew, because as I started reviewing them, I realized that we'd never have enough time to get through all of them. So some of them that have somewhat reduced interest, I will give short shrift to and spend more time on the ones I think that are important. First case we're going to discuss is Truck Insurance Exchange versus Amco. This is a dispute between two insurance companies as to who bears the burden of paying off the damages. In this case, we have an owner of real estate. There was an accident on the property. The car got out of control and slammed into the front. They repaired it. And then sometime later, they leased it to the tenant. The tenant was insured by Amco, and the landowner, lessor, was insured by Truck Insurance Exchange. A few years later, another car crashed through the front of the restaurant and pinned the Smiths, who were having dinner, probably interfered with their dessert, and pinned them against the wall. So they first sued the tenant who was operating the restaurant, and then later joined the lessor. That brought into play both insurance companies. And the question was, as between the two insurance companies, who's going to pay the bill? And the argument made by Amco, the insurance company for the lessee, was that had absolutely nothing to do, the incident had absolutely nothing to do with the running of the restaurant. And that the liability really fell on the landlord for failing to adequately take precautions and put up barriers and so on. The truck insurance argued that it had everything to do with the operation of the restaurant. If there wasn't a restaurant, the Smiths wouldn't be in there eating dinner. And that was the primary use that created the exposure. And the court agreed with Truck that it should be the tenant's insurance company that pays the bill. Next case, Struxma versus Aqua Loan Servicing, deals with the preclusive effect of an unlawful detainer action. In this case, Struxma owned a piece of property that was encumbered. He defaulted on the loan. They started foreclosure proceedings. Before they started foreclosure proceedings, and then followed it up with an unlawful detainer. After the unlawful detainer, Struxma filed a lawsuit against the lender, the usual things of wrongful foreclosure and things like that. And the trial court said, well, you can't do that because you've already had a hearing. That was the unlawful detainer, and it resolved these issues. The Court of Appeals said, no, it didn't. An unlawful detainer is a summary procedure with relatively limited discovery, and it really isn't a fair and complete discussion of all the issues. The only thing it resolves is whether the defendant has the right to remain on the property. It doesn't resolve anything else. So even though there was an unlawful detainer and a judgment for the lender in regard to the right to possession, that didn't preclude Struxma from filing a lawsuit for the various violations, including wrongful foreclosure. A case we're going to skip over is Mannequin versus Peters and Freeman. This was a case dealing with whether a bankruptcy discharge barred a fair credit violation. In this case, Peters and Friedman were the law firm representing the homeowners association. It was a failure to pay the assessment, so they proceeded to file a notice of default foreclosure. The debtor filed for a Chapter 13 plan that provided for a complete payment of the debt. The debt was paid in full, and for whatever reason, I can't imagine, the law firm then proceeded to proceed again with the foreclosure on a debt that had been paid in full. So there was analysis of whether to what extent the bankruptcy affected the ability to proceed on the fair credit reporting. Brown versus Montage at Mission Hills deals with Civil Code Section 4740. 4740 provides that no owner in a common interest development may be subject to a provision in a governing document or an amendment to a governing document that prohibits the rental or leasing of any of the separate interests in that common interest development. Those of you who've been following along, short-term rentals in dwellings that are part of a common interest development are becoming an increasing problem in that there are problems with the tenants who really don't have a stake in the property, and attempts are regularly made to try and limit that. The plaintiff in this case, Brown, had bought her property in 2002 and almost immediately began leasing it out for terms of 30 days or less. When the Homeowners Association 15 years later in 2018 amended the CC&Rs to preclude rental for 30 days or less, Brown filed an action for declaratory relief, saying, look, I bought the property in 2002. In 2002, this restriction didn't exist. This is exactly the sort of thing that 4740 was designed to prevent. The Homeowners Association came up with an interesting argument. They said that the provision in the CC&Rs did not prevent renting the property. It only prevented renting it for 30 days or less. It could be rented for 30 days or more, and therefore it wasn't included under the statute. The court went into a detailed analysis, including the legislative history, and they concluded that the legislature's intent was to provide as much protection as possible to a homeowner having the right to rent out their unit. And as such, they interpreted that section as precluding any restriction against renting, whether it be for a month, a day, a week, or a year. Next case we'll discuss very briefly, Chinese theaters versus County of Los Angeles. In this case, the owners of the, used to be called Grauman's Chinese, I don't know what it's called now, entered into a theater naming rights agreement, and the assessor raised the assessed value of the property based on the entry into this agreement. The theater made the argument that this was an intangible asset and therefore wasn't subject to property tax. The court agreed. The issue on appeal was the right of the taxpayer to recover their legal fees, which turned out some rather detailed analysis of what the holding was. It's an area you practice in, you might want to take a look at the case, otherwise you could probably pass. Villanueva versus Fidelity National Title Company. This was a case that involved the right of consumers to sue insurance companies for charging for items not approved by the insurance commissioner. As you may know, the insurance commissioner really basically has to approve any charge by a title insurance company. In this case, the title company was suing for courier delivery, drawing deed fees, and so on, without having them approved by the insurance commissioner. These are commonly referred to in the trade as junk fees. The question was whether the consumers were precluded from suing the insurance company because of a provision in the insurance code, which basically provided that disputes over title insurance charges were resolved with complaints to the insurance commissioner. The court said that's true if these were insurance rates, but these were not insurance rates. They were other mixed charges, and there's nothing that precluded the consumers from going directly against the insurance companies. Wells Fargo Bank versus Mahogany Meadows is a curious case in view of how the court reached its holding. Now, this was a case under Nevada law, although it's a Ninth Circuit case. In this case, the owners of the property got a loan from Wells Fargo. They fell behind in their homeowners' assessments. The homeowners proceeded to take action to file their lien and proceed to foreclose. In Nevada, there's a statute that provides that homeowners' liens have a super priority, so that in effect they are ahead of the Wells Fargo deed of trust. As a result of the Wells Fargo lawyer dropping the ball, Wells Fargo didn't bid in and cure the assessment. And as a result, when the property was foreclosed, the homeowners association bid in the $535,332 that was owed. There were no other bidders, Wells Fargo falling asleep at the switch, and acquired titles of a property that was worth over $200,000, wiping out Wells Fargo's mortgage. Wells Fargo challenged the statute, and by the way, this almost certainly wouldn't happen in California, because CC&Rs in California almost always have a provision that says, although assessments have a super priority, it's only assessments that are more than 6 months old, so that there's a certain amount of control. That's to meet Freddie Mac, Fannie Mae requirements. They argued that this statute violated the takings clause and the due process clause, taking property without compensation, and that it was statute was unconstitutional. Here's where the case gets interesting. The court held that it was not unconstitutional because there was no state action. The action was that there was no action that constituted taking because the foreclosure itself was not a taking, as the homeowners association was a private actor, not a government entity. This may remind some of you of the recent US Supreme Court decision involving the Texas law that virtually made abortions impossible by arguing that the state didn't enforce it. It was enforced by individuals who would file a claim and then get a fine. from the person who received the abortion. This is a reasoning that is fraught with potential errors. For example, if in a very blue state like California, the legislature passed a law that provided that the ownership of assault rifles was illegal, but that it was enforced by private citizens reporting and getting a fine. Would that blow the Second Amendment out the window? Sometimes when courts make decisions, they don't think it out. See where that goes. Phyllis versus County of Humboldt. In this case, there was a trustee sale. And the person who bought at the trustee sale said that this satisfied the open market transaction requirements, and that the new assessed value of the real property bought at the foreclosure was the price bid in at the foreclosure sale. The court analyzed what it meant to be an open market transaction. The Revenue and Taxation Code, section 110A, defines real property fair market value as the amount of cash or its equivalent that property would bring if exposed for sale in the open market under conditions in which neither buyer nor seller can take advantage of the issues of the other. The foreclosure sale doesn't do that. The interest of the foreclosing party is to get back the amount of its encumbrance, not the fair market value of the property. So that the county assessor is not bound by the purchase price of the foreclosure sale in determining the fair market value of the property. Whereas in an arm's length transaction between individuals in a normal purchase sale transaction, the price paid would be considered arm's length and fair market value. Versus Petro. This is a case involving a lease that the landlord, that the tenant. This was probably a land lease because the tenant had permission under the lease to encumber the leasehold estate, which he did. So now we have three parties. We have the landlord, we have the tenant, and we have the lender. The lease not only provided that the tenant could encumber the property, it also provided that in the event of a dispute, the prevailing party got their attorney's fees. All three parties got into a dispute. Question: is the lender on the deed of trust able to recover his attorney fees? He's not a party to the lease. Court said yes. They, in effect, were a third-party beneficiary. Since the lease allowed the tenant to encumber the property, the encumbrancer was allowed to recover their attorney's fees in the dispute. Next case, Pear versus City and County of San Francisco, is a case involving an easement with a reservation of rights. And the reservation of rights permitted ornamental landscaping. They wanted to use it as a parking lot, which is about as much of the cases we're going to discuss. Court held it didn't go that far. Tiburon Belvedere Residents United to Support Trails versus Martha Company. Martha Company owned 110 acres of undeveloped trees and trails and so on that were used for a variety of purposes, including hiking, running, biking, horseback riding, and so on. The plaintiff, a public interest group, sought to get a declaration that there was an implied dedication for the use of the recreational trails. At trial, there were lots of witnesses who said, yeah, we used it all the time. But they were all neighbors. No one came from the next county or from miles away. They were adjacent to the property. And there were no trespassing signs on the property. And whenever the owner saw someone, he shooed them off the property. He said, under that circumstance, even though there was a lot of use, it didn't rise to the level of an implied dedication because of the nature of the use. Bailey versus Citibank. In this case, the owners of real property got a loan from Citibank. The owners defaulted. Citibank was in no rush to declare a foreclosure. They filed a notice of default, but they just let it sit. At that point, the Baileys moved on to the property and stayed on the property for 5 years, holding it open and notoriously paying the taxes. So not surprisingly, at the end of 5 years, they said, okay, title of the property is ours. So when the bank attempted to foreclose, they said, you can't foreclose, your interest was wiped out by us. The court held, no, it wasn't. You can't be adverse when the interest is merely as a beneficiary of deed of trust. They don't own the property. It's adverse against the owner, but the owner's being foreclosed out. The only way it can be adverse to Citibank is after Citibank foreclosed and was the owner of the property. That would start the 5-year adverse period. So the period of time in which Citibank was no more than a beneficiary doesn't count. Russos versus Russos is a case involving disqualifying a neutral arbiter. Parties agreed on a neutral arbiter. 5 years later, one of the parties discovered that the arbitrator had an interest that should have been disclosed and wasn't. And the question was whether they could, at this point, still seek to disqualify the arbitrator. For reasons discussed in greater detail in the decision, the court held that they could disqualify the arbitrator. Next case, quite frankly, I'm not sure what to do with. This case is Carton versus Ari Design and Construction. Some of you may know that the Carton is David Carton, who's had a domestic relations practice in Beverly Hills for at least 50 years. David and I actually practiced together as associates long ago in a galaxy far, far away. This is the third time David's name has appeared in a Court of Appeals decision. The other two are Carton versus Dougherty, 231 Calat 4th 600, a 2014 case, and Carton versus Segreto, 176 Calat 4th 1, a 2009 case. Both of them involve litigation over the reasonableness of David's fees. It should therefore not come as a shock that Carton versus Ari Design and Construction has a similar issue. In this case, David and his wife hired Ari Design and Construction to do some remodeling on their home. After 6 months, they found out that Ari was not properly licensed and not properly insured. So they instructed Ari to stop work. At this point, the Cartons were ahead of Ari in terms of payment. They had overpaid. There was no dispute that there was an overpayment. Ari agreed it was overpaid. The only question was the amount of the overpayment. The Cartons claimed that they had overpaid by $35,000. Ari claimed the overpayment was only $13,000. So we're looking at a dispute of $22,000. After the Cartons prevailed, they sought their attorney's fees, requesting $270,000 in attorney's fees, $50,000 in discovery sanctions, and $200,000 for proving matters at trial that had been denied during discovery. The judge asked for some briefing to justify this and allowed them a chance to supply evidence subject to a 10-page limit. They then proceeded to file an 11 pages of text and 400 pages of supplemental briefing, and also asked for an additional $16,000 to cover the cost of doing that. The case is very instructive, not only for the outrageous nature of the fees, but for the court pointing out that this case was over litigated. There was a lack of civility in the pleadings. That says the papers filed contain a lot of extraneous documentation. It was emblematic of over litigation. And that an award of 3 times the recovery was unreasonable. They did award $90,000 in attorney's fees, which was upheld on appeal. I've been practicing a long time, over 50 years. And I remember when lawyers would slug it out in the courtroom, break for lunch, and go out and have lunch together. There was a civility to it. The legal profession was a profession. Now it's, to a large extent, turned into a very confrontational proceeding. And the state bar is undertaking now a review to try and restore some of the civility. A reminder that lawyers that we aren't the litigants, we're the professionals representing the litigants. We don't have a direct dog in the fight. And general rudeness and incivility should not be allowed. In that respect, I'm aware of a situation in case that I'm involved in which the defendant filed a cross complaint, which turned out to be covered by insurance. So by the time the insurance company got the file and reviewed it, they were close to the answer. So they asked for a courtesy extension of a week or two. Lawyer said, no. That's what makes litigation aggravating. And I've seen the same problem happen in transactional matters too. Champier versus Fairbanks Ranch Association. This was a case involving whether a party can be considered a prevailing party when they dismiss the lawsuit. Here the court said they did. In this case, the homeowners association decided that they were going to install entrance gates and traffic lights on the homeowners association property, located at gate number 1 and gate number 6. When they started to install the lights, they changed the plan. They still were going to do gate number 6, but they were now going to do gate number 2 as opposed to gate number 1. Plaintiffs sued, arguing that they didn't follow the procedures in the CC&Rs to provide that it should be done at gate 2 rather than gate 1. It shouldn't surprise anyone that this homeowner's house was located at gate 2. There was a TRO issued. During the interim, the association had a new vote. The new vote specifically provided for the traffic light to be installed at gate 2. And as such, there was no dispute left. So the plaintiff dismissed the lawsuit and sought their attorney's fees. Defense argued, well, you dismissed the lawsuit. How can you consider yourself the prevailing party? The answer is, the lawsuit was designed to make the association have another vote to approve the change. The association had another vote to approve the change, so I accomplished what I filed the lawsuit for. And the court agreed that they would be considered the prevailing party and they would be entitled to their attorney's fees. Starchevic versus Pentec Financial Services. In this case, the appellants were a lien holder defendant in an underlying action involving 4 properties. Pentec obtained a judgment on its lien and was determined to be the priority lien holder by the trial court in 2015, pursuant to a stipulation by the parties. Pentec's judgment expired in March of 2018, but it failed to renew the judgment. The court held that by failing to renew the judgment, Pentec lost its priority. And even though it thereafter renewed the judgment, because there was a period of time where it had not been enforced, their priority status was lost. Paviani versus Arbors at Cal Oaks property. Cal Oaks property was an apartment complex with a common area. And the tenants filed a class action alleging false advertising and breach of warrant of habitability. The defendant argued that it was inappropriate to treat this as a class action because each party's claims were different and there wasn't a sufficient commonality to justify it as a class action. The court noted that the claims all related to the common area, so it was all the same piece of property. And the issues were sufficiently similar that they could proceed as a class action. Since we have time, let me go back and cover some of the ones that we didn't cover in detail. Going back to Mannequin versus Peters and Friedman, the argument was that the bankruptcy discharge would act as a bar the FDCPA claim. In this case, the Mannequin filed for a Chapter 13 bankruptcy. As part of that Chapter 13 bankruptcy, he agreed that he would pay in full the lien to the homeowners association. He paid the lien to the homeowners association. The homeowners association was notified that the lien was paid in full. But Peters and Friedman, the law firm representing the homeowners association, nonetheless refiled the default and sought to enforce it, which obviously was a clear violation of the act because no money was owed. The argument was that the FDCPA action was barred because of the debtor's bankruptcy. And the court held that it was not a bar to that action, that it did survive, especially since it occurred after the discharge was issued. Chinese theaters versus County of Los Angeles. As I said earlier, this was a dispute over whether a theater naming rights agreement was subject to property tax. And the court held it was an intangible and therefore exempt from property tax assessment. The question was whether the taxpayer was entitled to recover their attorney's fees. And the court laid out the requirements for getting attorney's fees in such a transaction. They said that the attorney's fees are properly awarded only if the county board failed to make requested findings, and when a court determined the board's findings were so deficient or arbitrary that it must remand the case back to the board to make appropriate new findings. The court held in this situation, neither of those occurred, and that therefore attorney's fees could not be provided.
Larry, I don't know if you want to go over the case before that in your list is Bonet versus County of Santa Barbara.
Did I miss that one? Shame on me. Thank you for pointing it out. Yes. Oh, yes, here it is. It was one of the ones I wanted to discuss, actually. In this case, the owners of a single-family residence put it in their family trust. When they passed away, the property was bequeathed in equal parts to their children. They had 13 of them, which meant that each child had a 1/13 interest in the home. Now, upon the transfer to the children, they applied for a parent-child exclusion to prevent the imposition of a increase in taxes. Thereafter, one of the 13 acquired the interests of the other 12 and also filed as a parent-child exclusion. The assessor held that he was not entitled to the parent-child exclusion because he didn't get the property from his parent. He got it from his siblings. And that in fact, there was a 12/13 change in ownership that required a reassessment of the property. Now, why are we even talking about this case when we all know under Prop 19, thanks to the California Association of Realtors, you can't use the parent-child exclusion. Now, there is an exception. And the exception is if you move into the house. That exception wouldn't be available here because of the second transfer. It's not unusual when you have a home owned in the trust and one of several siblings wants to keep the family home and the others are just as happy to sell it. Well, that can't be done in view of this case, even if the person acquiring the property moves into it. They can't avail themselves of the exemption under Prop 19. So as a practical matter, unless there is a single beneficiary who gets title to the entire house, you're not really going to be able to use the parent-child exclusion because it's not considered, because an acquisition from your siblings isn't considered coming from the parent. I will use a specific example of an issue that I'm dealing with right now. You've got a parent with 2 children. They're leaving the house equally to the 2. One doesn't want the house, wants to be cashed out. The other wants to keep the house. Why? It's a smaller home. They're getting on in years themselves. They like the idea of possibly being able to move and downsize at one point in the future, but they're not ready to do that yet. So the plan prior to Prop 19 was they'll buy out the brother's interest. They'll rent out the property as income property, so it'll carry it. And when the time comes, they'll eventually move into it. Now it becomes economically unfeasible because there'll be a reassessment. The property happened to have been purchased 25 to 30 years ago. So you can only imagine what the increase in property tax would be. So why on earth did the California Association of Realtors push for Prop 19? They kind of ignored the parent-child exclusion part. And to the extent that it arose at all, they'd remind people that Lloyd Bridges' kids, Jeff and Bo, inherited his Malibu home and they rented out for a tremendously large rental amount. And then it was reappraised, it would be substantially increased in value. And said, well, these are people who are gaming the system. Problem is that it's a very rare circumstance where someone is gaming the system like that. So why were they pushing for it? Well, the exchange for giving up the parent-child exclusion was that the ability to transfer your basis in the property from one property to the other, if you were over 55, was expanded. Well, if it's expanded and your property tax is going to go up, that encourages people to buy other property. And that obviously benefits the membership. So I can only suggest when you read the discussion in the ballot about the pros and cons, look to see who is supporting the pro and who is supporting the con. That may give you a little bit of idea of who's pushing what. Okay.
You also have increased sales because of the lack of the loss of the parent-client exclusion, and people can't afford to keep the property.
Well, with the increase in taxes, that's the case. It can be a significant increase in taxes, which means that when they rent the property, they have to charge more rent, and that increases consumer rental costs. So.
Yeah, Boyer versus City of Simi Valley.
And what?
Boyer versus City of Simi Valley.
Oh, it's really an esoteric case. In Boyer, the city adopted an ordinance prohibiting mobile billboard advertising on any public street, authorizing police officers to impound mobile billboards. Certain authorized vehicles were exempt from the ban. Boyer, the plaintiff, used his mobile billboard for advertising, which therefore was banned. And the question is, if you're banning some, you have to ban all. That when you're banning non-content neutral advertising, there's a strict scrutiny applied because you don't want to violate the First Amendment freedom of speech. So it's an interesting discussion of the free speech activities and protections afforded to advertising. And beyond that, I don't think there's no time to go into. What else do we do?
Westwood Homes, Inc.
Excuse me?
Westwood Homes, Inc.
Inc.
Third from the end.
In this case, the plaintiff obtained a judgment and then sought to amend the judgment to request attorney's fees from a third party who was not originally a party to the lawsuit, proceeding on the basis of piercing the corporate veil. And the question was, can they do that by amending the judgment, or must they file a separate action? And the court held that because of the related interest of the parties, they could simply move to amend their respective judgment to add that party upon a showing of that they were able to successfully pierce the corporate veil. They didn't have to do a whole lawsuit all over again. Any others I missed, Howard?
Those are the ones that I noted as you were going through everything. And I don't have questions in chat or Q&A. So unless we have something else that people want to know about, I'm going to thank you for once again doing this program, Larry, and appreciate it. You know, every year it's interesting to see, you know, what sort of monumental cases we have come down and others that seem to be sort of more incremental in what they're accomplishing. And of course, every year we seem to have property tax issues coming up because it's just so much money.
Surprisingly enough, this year there were no cases involving real estate agents. Maybe they've been behaving themselves.
You know, we did just do a program on the CAR, their new residential purchase agreement form. And for anyone who didn't attend that program, the new form adopted a lot of the things that sellers have forced on buyers in this seller's market. And so the form has become a lot less friendly to buyers than it used to be, including leaving open issues like who's paying the transfer taxes, which in Southern California used to always be the seller. And I think when we hit the buyer's market, we're not sure when that'll happen, but it'll happen at some point. The lawyers are going to be busy, or the real estate agents will be busy rewriting and crossing out parts of the form that the buyers aren't happy with.
It used to be that lawyers would complain that understanding the residential purchase agreement was beyond the ability of a real estate agent who hadn't been trained in the law. CAR has taken corrective action by producing a form that not even lawyers trained in the law can fully understand.
The form went from 10 pages to 16 pages. And
I remember when it was one page.
yeah, and there are some improvements in the form. There's what they call the in-house at CAR, the grid at the front that sets forth the negotiable terms and sets forth all the contingencies, hopefully most of them all in one place. And there are some improvements like that, although they still don't identify who the seller is until the last page of the agreement. Not the way lawyers normally draft their agreements.
No, and we don't.
Thank you, Larry. And Thank you, everyone who's attended, and hope we'll see you at next month's program to learn about what propositions regarding property taxes we may be debating about in the fall. Thank you again.